So today we have a distinguished panel that's going to talk about the impacts of Title VI, as well as where there's room for improvement. I'm going to introduce them in the order in which they will speak. I'm going to first begin with Dr. Erica Frankenberg. Dr. Frankenberg is a professor of education and demography and the Social Science Research Institute Associate Director at Penn State University College of Education. Dr. Frankenberg was the co-founder and now director of Penn State's Center for Education and Civil Rights, former director of the Initiative on School Integration for the Civil Rights Project at UCLA, and her research has been cited in U.S. Supreme Court decisions, including the most recent case on voluntary integration, where she co-authored a social science statement describing the benefits of integrated schools, signed by over 500 social scientists. Jenny Lee is the Director of Strategic Initiatives at the NAACP Legal Defense and Educational Fund. Lee oversees LDF's Pro-Truth Initiative, which builds upon LDF's legacy in Brown versus Board of Education to protect the truth of the United States history of racial subjugation and its ongoing impact on present-day systemic inequalities, especially as taught in K-12 and post-secondary public education. And she led LDF's representation of a multiracial coalition of 25 Harvard student and alumni organizations, which served as amici curiae in Student for Fair Admissions versus Harvard. Next, we have Oscar Jiménez-Castellanos. He's the executive director for the Center for Latino Achievement and Success in Education and the Goizueta Foundation Chair of Latino Teacher Education at the Mary Frances Early College of Education at the University of Georgia. He specializes in education policy and finance equity for traditionally marginalized populations. And then last but not least, we have Derek Black. He's a professor of law and the Ernest F. Hollings Chair in Constitutional Law at the University of South Carolina School of Law, where he also directs the law school's Constitutional Law Center. He's the author of a leading education law casebook, Education Law, Equality, Fairness, and Reform, and two other books aimed at wider audiences, Schoolhouse Burning, Public Education, The Assault on American Democracy, and Ending Zero Tolerance, The Crisis of Absolute Discipline. His work has been cited by federal courts and various briefs before the United States Supreme Court. And with that, I'm going to turn it over to Dr. Frankenberg.
Thanks. It's great to be here. I'm starting in part because I'm going to give us a little bit of a history lesson before we go forward in thinking about where Title VI is today. And I think this is both helpful for us to remember as we celebrate the 60th anniversary how it has been used in the past. But it's also working on a second level here in that I think it's really important for us to take account of history today as we're trying to show the ways in which discrimination is continuing to work. And so this is working at both a macro and a micro level, because I think without going through the history, it's harder to show the ways in which ostensibly race-neutral policies are in fact having a very racially disparate impact. So apologies in advance if I am reviewing history that you know. But the history of the Civil Rights Act I think is actually a really important one that is often less understood when we talk about, perhaps particularly in a law school, you're probably taught a lot about Brown as a success. And yet a decade after Brown, very few Black children were not in segregated schools in the South, which is where most segregation was in 1954. And so what happened in the mid to late 1960s, where we had a dramatic expansion of desegregation in the South, was in part the result of the Civil Rights Act of 1964 and the Elementary and Secondary Education Act in 1965 has been reauthorized several times, now known as the Every Student Succeeds Act. But that was a dramatic expansion of funding for federal funding. Federal funding only accounts for about 10% of schools today, and so it's a very small amount. However, in the South, it matters a lot. As I told Ari after the last slide, I grew up in Alabama schools, which my high school was not air conditioned. So they have typically been less well funded, and that's why federal funding meant so much. So there was this expansion of aid in 1965, and 1964 Civil Rights Act had this provision, Title IV, in which it said you cannot be guilty of racial discrimination and receive federal funding. And that applies not just in education, a lot of other areas as well. But it mattered a lot the next year when they then passed the expansion of federal aid. And the way in which ESCA was done was that every congressional district got funding, and so it mattered for everyone. So there was this 1-2 punch that was really powerful, and particularly since we didn't really have clarity from the Supreme Court until the late 60s about what desegregation meant, this was a really important moment to help move along desegregation in the South. So I talk about it, and I'm happy to share more resources later. The way in which my research shows they sort of acted in this way in which they mutually reinforced each other. When legislators in Congress realized the way in which this was having an impact, they then tried to see if they could limit the way in which these statutes were being constructed, because I think they didn't mean for it to quite have the effect that it did. But what happened is the Office for Education, which was the predecessor to today's U.S. Department of Education, sequentially issued these annual guidelines about what it meant to be in desegregation compliance. And at the time, this was, fairly minimal work, basically to get rid of completely segregated schools, and to sort of slowly advance over time both student segregation and teacher desegregation. And so, in order to meet the requirements, you had to be in compliance with these guidelines, which again was a time in which we weren't getting a lot of input from the courts about what did desegregation mean. And so, this really helped to fill in the gap at the administrative agency level. Um, One of the downsides I'll say is that this, because they were, and this is true today as well, they were very understaffed and under resourced. So they predominantly focused their efforts on where they could have the most impact. And so that was schools in the South, and particularly in the Deep South, quite frankly. Um, so they left unresolved, by and large, efforts of segregation outside of the South. And as I'll come back to, that, of course, is a key weakness that we have never fully addressed. But I think it helps to demonstrate that there was tremendous success. And by the 1970, Black desegregation was higher in the South than in any other region of the country. So when they put these tools in place, and by the 1970, the courts had come back in with Green defining what desegregation meant. We also had then the agency stepping back because of some decisions that the Nixon administration meant. So it was a brief window, but it was a really powerful one. And I'll just show you a couple of statistics. During the Johnson administration, there were these findings of noncompliance by school districts. And so there weren't a lot of numbers here, right? There were only a few in which funds were deferred, only a dozens of districts in which funds were terminated for a brief period. This wasn't massively cutting off funding, but there was a threat that they would do it. And that might be an effective technique that many of us respond to in lots of different ways, and including these school districts that need the funding. So the Johnson administration did enforce this. They were limited in what they could do, but I think it's really important to see that they did. One place in which the first limitations start to come into place is the Office of Education was investigating the city district of Chicago. And Richard Daley was the mayor of Chicago, and he was one of Johnson's political allies, and that they then brought pressure to bear and basically stopped that. And so it was really challenging to see that how that was then going to affect sort of the de facto or the non-de jure districts. The other thing just to mention is there was a study that looked at sort of the effect of this in districts that were under the Office of Education versus courts by 1968 and 70. They had more integration under the administrative agencies and the Civil Rights Act enforcement than they were under the courts. That then flipped. But again, another indicator of how empirically this really had a pretty substantial impact. This then in turn affected and informed the court's findings as well. So when we think today about where we are, on the previous panel, they talked about de facto segregation. Um, I think from a social science perspective, school segregation exists, and it exists for a lot of reasons, some of which involve the law, and some of which don't involve the law. And I think for me, it's helpful to think about the myriad of reasons. And so I put these in buckets here. There's educational policies that directly affect school segregation. There are non-educational policies as well. There are private actions that are still regulated by government policies, and then there are the legacy of prior governmental policies. I would argue in an expanded understanding of Title VI in a proactive way when we're thinking about why we see persistent racial inequality and segregation, unequal resources. We can look at all of these different reasons as related to government action or inaction. And if we're thinking about broadening out how we use Title VI, this could be one way of doing it. So briefly, I want to talk about two different mechanisms that affect the majority of ways that students are assigned today. One, the vast majority, 70+% of kids go to the school in which their home is attached to a zoned school. We know already from Ari's pop quiz earlier that boundaries are not, as I like to say, ordained by God. They, in fact, are political constructions and therefore can be changed by the political process. This matters within districts and between districts. So Ari took us through between districts, and that's crucially important. In the interest of time, I'm going to focus on within districts. This is Howard County, Maryland. It's a big fuss a few years ago, rezoning the high schools to make for more economically integrated spaces. So we studied, and we have a larger project studying how school attendance zone boundaries are changed, and are they being changed in ways that promote integration. What you see here is by and large the green area on the left in this map. Most of the county during a 30-year period had their attendance zone boundaries changed. So this is something that is happening a lot. But what you see in the graph on the right is to the right rather, when you had higher percentages of areas that had higher Black residents, you are more likely to have your boundaries changed. And again, this isn't surprising given what we know elsewhere, but we continue to see that Black residents have their boundaries that are being rezoned. And so we need to think, of course, about also how these changes are affecting the burden. We see, too, in studies of this and elsewhere, that boundaries aren't being changed in ways right now that do as much as they could to integrate. And so I think it is something that it goes on in every school district. And so there, again, if we're thinking about levers, it is a ubiquitous one. Almost every district has it. What we need to also think is how do we use them in ways that can further the other policy goals we have in combination with others like proximity and things like that. And so this is one in which I think Title VI could do an examination of how are we changing boundaries between districts, as well as certainly when we are changing boundaries between districts as well. Okay, I'm getting confused. And then the second is thinking about school choice, which again has already been called out. I think it's helpful to distinguish what we mean when we say school choice. So I think generally both the design of school choice policies and the implementation is going to matter as to whether they further segregation or whether they interrupt segregation. And in general, because we live in a segregated, stratified society and we have unequal, segregated social networks, if you don't take efforts to sort of mitigate the effects of choice, they will segregate. So I have here a couple of ways that unregulated school choice, typically the research shows, further segregation. Vouchers, mini charter schools, open enrollment that is within or between school districts, all of those choices are very unequal. I'm happy to talk more about it later. There are also some efforts of school choice to encourage voluntary integrations. Magnet School Assistance Program is the one federal funding program that furthers integration. And in fact, the Magnet School Assistance Program, because of the Civil Rights Act, have to review desegregation plans before the funding is awarded. This could be bolstered, but it is a really important start in terms of how we think about racial discrimination. I've also listed some other ways here too as well that choice could enable voluntary integration. voluntary integration is not going to get us out of the massive segregation that still exists, and it certainly is not going to do anything to disrupt the residential segregation that we have to concurrently address. But I think it is really important here. And the last thing I'll just say for now is that in order to get either at school choice or at changing boundaries, these are going to be really intensive investigations that we're going to need to mount. That takes a lot of resources. OCR in the Department of Education has about a third of the resources that EEOC has. And it has had an expansion of cases since the Obama administration started, and yet fewer people doing it. So they're by and large only responding to complaints. They're not doing proactive investigations. They're not getting the data that we need as discrimination has adapted to really be able to show the ways that privatization, choice, boundaries, these are more complex arguments we have to make. And so we need a lot more efforts to try to address that. And so I'm happy to talk a little bit more about this, but hopefully, at least how I see how it has been used in the past and hopefully could be used in the future to help us further integration.
Good morning. First, I want to congratulate the Education Rights Institute on its one-year anniversary, and to thank the Institute for inviting me to this very, very accomplished panel. And you know, to end, I think it's very important to take this moment to recognize the 60th anniversary of this Title VI of the Civil Rights Act of 1964. It's also the 70th anniversary of the Brown v. Board decision, and to have, you know, obviously they both are, they work in parallel and support each other and are very much, and has been very much instrumental in reshaping our educational system. We can imagine when we think about the public education system in 1954, when the decision came down and there was this entrenched, you know, explicit de jure segregation of our public school systems, and to take on that daunting task of integrating these school systems, as well as really battling the resistance that occurred all throughout the South. And it's really because of the great work of the federal government, the Department of Justice, as well as the Department of Education's Office of Civil Rights, which has always been a partner to us at the Legal Defense Fund, to do that work back, you know, decades ago, and to continue doing that work. And many don't realize, but we actually do have quite a few school desegregation cases ongoing, and I think no one would pretend that or profess that the work has been finished, or that we've really accomplished all of the goals that were intended in the Brown decision, as well as Title VI. So there's obviously a lot to celebrate in terms of Title VI. I think that what we must kind of be clear-eyed about, though, has been some of the challenges. And I think it's important for us to recognize those as we look at the next 60 years and hopefully make even more progress when it comes to not only racial desegregation, but also racial equity when it comes to our educational system. And just to kind of outline some of the more heightened challenges. One is the fact that private actors like the Legal Defense Fund and our clients have not been able to enforce the disparate impact regulations, and that was from a 2001 decision, Sandoval, which has been highly criticized, but it really prevented, for the students and the families who are experiencing the harm to be able to go to court and really enforce Title VI in the most robust way, and leaving it to the federal government to enforce those regulations. At the same time, because of the precariousness of disparate impact right now, the Office of Civil Rights at the Department of Education really has not been enforcing the disparate impact regulations. So that potential in terms of civil rights enforcement has really been underutilized. And then there's also just the frankly, the lack of a sufficient funding for the Office of Civil Rights at the Department of Education. Um, we LDF is part of a coalition of civil rights organizations that number in the hundreds that in February sent a letter to the Biden administration recognizing the incredible lack of resources that OCR has right now in terms of addressing all of the many complaints that have been filed. And just to give you some sense of that, from 1981 to 2022, the number of complaints submitted to OCR increased sixfold. But at the same time, the OCR staff has decreased by one half. And this is between 1981 and 2022. So you can imagine that they probably did not have enough staffing in 1981, and let alone to have that staffing decrease by 50%. And that increases, it's increasing, every year. Between 2008 and 2019, there was a 187% increase in civil rights complaints, Title VI complaints, and just last year it was the record number of complaints that were submitted, so 19,000. So when we talk about having this infrastructure, under Title VI to allow students who are suffering from various forms of discrimination, and to have this this legal remedy so that they can actually kind of explain and report the violations, the understanding is that there would be some sort of relief, or that there'll be some sort of action. And when in fact, just to give an example of one of our clients, we have an ongoing Title VI complaint with OCR, and it's one of the most egregious examples of discrimination. We're talking about persistent racial slurs, against Black students that have gone unaddressed, families who have also incredible harassment for gay students, gay and lesbian students, as well as students who are non-binary, to the point where students had to seek mental health treatment, transfer to other schools. Some families actually left and just moved away because of the incredible harassment, not only against the students, but to the families. And this complaint has been pending for over 3 years. So when you think about 3 years in the life cycle of a student, I mean, that's their entire high school year. So this is just one kind of concrete example of the consequences of this lack of sufficient staffing. The other kind of recent challenge has been the affirmative action decision that was issued last year in SFFA versus Harvard and UNC. And, traditionally, affirmative action has been an equal protection issue, and the challenges have been brought under the Equal Protection Clause of the 14th Amendment. The 2023 case involved Harvard, which is a private university. So the claims in that case were premised on Title VI. So when the Supreme Court issued its decision, they kind of, with not much analysis, equated the analysis under the Equal Protection Clause with Title VI. And I think for lawyers and anyone who actually read the decision, it's very clear that the decision is very limited in scope. It's limited to the explicit consideration of race as one of many factors in university admissions. It's nothing to do with K through 12. It has nothing to do with curriculum, or there's a lot of other issues like that face school systems, as well as racial barriers and other areas like in the employment context and so forth, that would not be touched by this decision because of this very unique body of law when it comes to affirmative action higher education. And yet, because that decision was issued, there's been a lot of embrace and excitement among, frankly, extremists to take that decision and kind of run with it and really challenge kind of any efforts to address, barriers to opportunity, let alone educational opportunity. And so what we're seeing is a backlash that I think is something that has to be considered when we're thinking about both using Title VI, but also kind of the end goals and of what we want to achieve through Title VI, and then also how we talk about these violations. And just one, kind of just from the work that we've done, one thing that is just so crucial, and I think sometimes gets lost in the efforts to talk about whether it's Title VI violations or equal protection violations, is there's often been a shortcut when we rely on just racial disparities and saying that because there's a racial disparity, there is a violation. I think reasonable people would understand that these extreme racial disparities are a product of discrimination, but yet these extremists are really utilizing that language to make the case that what we are trying to achieve is diversity for the sake of diversity, and using race just as a proxy, as something that is in itself discrimination. And so as we talk about needing to use Title VI in order to enforce and to really achieve more racial equity, it's really important for us to really explain why that is discrimination and the underlying causes that created that discrimination in the first place. And we've seen that in challenges to critical race theory, diversity, equity, and inclusion practices. We've also seen that, to be honest, they're challenging social emotional learning. They're challenging everything that has the word equity as a form of trying to, for example, benefit Black students at the expense of other students. And what's lost is that kind of underlying assessment of what the status quo is. The status quo is not a system of of equality that kind of is kind of necessary for them to be, for their logic about why, efforts to advance equities in itself discrimination. The last thing that I would just like to say is just the intersectionality with Title IX, because what we're seeing is a tremendous attack on gay, lesbian, LGBTQ plus students across the board, and there is that intersection with students of color as well. And for many students of color, they are the most vulnerable. So there is that kind of, and there's been tremendous backlash and challenges in terms of OCR's interpretation of Title IX. So I will leave you all with that. There's a lot more to talk about, but thank you so much for allowing me to have these remarks.
I apologize. I don't have any fancy slides today. I tried my best to beautify my slides, but not to the point where I would want to get mocked by this prestigious group. But anyways, but I did, thank you, Kimberly, Dr. Jenkins Robinson, for the invitation. Congratulations on your anniversary. Thank you for the panelists to allow me to share this space with you all. And I'm going to bring in a different dimension of Title VI, which is really thinking about centering multilingual learners. And I'm going to use multilingual learners and English learners sort of interchangeably. When I use multilingual learners, I'm really focusing in on those students that have a primary language other than English, right? Because that's one of the issues right now with, the vogue term English multilingual learners, which I am completely in favor of. But then, are we then all multilingual learners? And what about those that don't have access to that, language of power here in the United States? So just wanted to clarify that when I do my remarks. And I'm going to sort of do a little bit of a timeline in terms of some key federal issues that have sort of are interplayed. Obviously, Title VI, the Bilingual Education Act of 1968, the San Antonio v. Rodriguez case of 1973, the Equal Educational Opportunity Act of 1974. This would also be the anniversary of the Equal Education Opportunity Act. Lau v. Nichols, as well as the anniversary of Lau v. Nichols, which was referenced in the panel previous to this. Castañeda v. Picard and Horn v. Flores. So let's see what we can do in 10 minutes, okay? We went over Title VI already, again, my emphasis is going to be the national origin, which says generally national origin discrimination means discrimination because of an individual or his or her ancestry is from a certain place or has physical, cultural, linguistic characteristic of a particular national origin group, right? So language here is going to be the key indicator. And in terms of language, in the most contemporary times, the Bilingual Education Act of 1968 was probably the first time federally that this was sort of explicitly addressed. And ironically, the Bilingual Education Act wasn't about bilingual education. It didn't mandate it. It didn't have any enforcement. It didn't require it. They did fund some pilot bilingual programs during that time. So I'm just throwing it out there, those of you who are nerdy about this topic, to really think about sort of the Bilingual Education Act. And I did a special issue on this with Franquis and also Jiménez-Castellanos 2018 in the Bilingual Research Journal if you want to know more about the Bilingual Education Act. So English learners, let's delve into English learners. A few stats were brought up earlier in the first panel. These stats are from 221, the national NCS data. 10% of all K-12 students in the United States are English learners. Texas, California, New Mexico lead the pack in terms of the highest percentages of students. However, I just moved from, the West Coast to the East Coast at the University of Georgia. And if you go from Florida all the way up to Massachusetts, so you have, or we have, a low of 5.8% English learners in South Carolina, Derek, where you reside currently, and a high of 12.5%. Can you guess which state? Rhode Island. Didn't realize that. And here in the wonderful state of Virginia, you have about 9.4%. I'm sure it's over 10% currently, just because it's a few years outdated. Again, higher percentage of English learners in the early grades. Most are native born, which was brought up earlier, and that's what a lot of people don't realize. And again, national origin doesn't mean that you're born outside of the United States. That's a really interesting sort of operational definition that is really important when we talk about English learners, because most English learners are born in the United States. They're distributed. So we're not all in the urban settings. We're not all in the urban. It really is distributed across urban, suburban towns, and rural. So you can't escape English learners, right? Even if you wanted to. 76% are Spanish speakers. The second most populous group is? Arabic. So, and obviously there's, hundreds of languages spoken throughout the country. But again, a critical mass, 76% are Spanish speakers. 93% of all English speakers receive some services. That means that 7% don't, which is a mandate. Georgia, where I reside in, has the lowest percentage of students served at 48%. Right. What is right, Erica? So the lowest four are Georgia, Illinois, which sort of surprised me, Wyoming, and Vermont. And this gets into the issue that I'll bring up later on in terms of staffing for the Office of Civil Rights, right? So Rodriguez, 1973, really look at the funding disparities between low wealth, high wealth districts in Texas. And really, in that decision, it was a 5-4 decision that ultimately said that, this isn't, education shouldn't be brought up as a federal issue. It needs to be resolved at the state. It was argued under the 14th Amendment, not the 6th, not Title VI specifically. Obviously, they're interrelated. But key takeaways from the San Antonio v. Rodriguez is, again, education is a state issue. many states, and this was also brought up earlier, many states have successfully sued for not adhering to state constitutions, right? So there's this state pathway that, has found some success in terms of school funding. The question is, what role could Title VI play in future school finance litigation? And I also recommend Kimberly's book on revisiting Rodriguez. Lubin Nichols, which I'm doing a special issue right now with Ofelia Garcia, Trish Morita Maleni, and Esther DeJong, in the Bilingual Research Journal, looking at 50 years of Lao. Lao really was the first civil rights case that looked at equity instead of equality. I think that's one of the big takeaways, meaning if I'm an English learner in a classroom and I'm receiving the same English instruction, right? That is equitable. That is the same, but it's not equitable because I'm not comprehending what I'm being told. So what really the Lavi Nichols case really set a precedent to say that we need to have meaningful opportunity. English learners need to have meaningful opportunities to participate. This starts a slew of sort of interesting but insufficient type of rulings. So the key takeaway here is equality is not equal or is not equitable. It does not mandate a program similarly to the Bilingual Education Act. So it's fuzzy. And then we know what happened. This was 1974. We know what happened, post 1980 with the politicization of bilingual education, which we'll get to in a moment. The Equal Educational Opportunity Act sort of just re-enhances or reinforces Title VI. And this, I think the Lau decision came down in January of 1974. The Equal Education Opportunity came down maybe July, August of 1974. So, and really sort of it requires state educational agencies and school districts to take action to overcome language barriers that impede English language learner students from participating in state and district educational programs. That was the emphasis for that. So this is how it's been translated, and now our dear colleague Hin could correct me since she's in charge of this. But basically, this is what you need to do to be in compliance. Provide a program, provide some resources, identify who is an English learner, communicate with the parents in a language that they can understand, make sure that special education that they're not overly represented, but they have access to special education if they need it, and they have access to gifted and talented programs. Okay, that's what it requires. So here's the downfall as I end up my talk. Horn v. Flores, 2009. It was a whole saga. I started off at Arizona State University, so I was right towards the tail end. I started in 2008. This decision was in 2009. But really, it looked at sort of appropriate actions. So it really was going after, it was really making the argument that the Equal Educational Opportunity Act was not being adhered to. It wasn't a school finance case, although it was about school funding, which is really interesting. If you really look, I said, there has to be something about the state constitution about how we fund schools, and it was never brought up. But the Horn v. Flores case allowed minimal funding, about 10% additional. It allowed segregation because you were actually able to segregate students for 4 hours a day, all English learners from kindergarten all the way to 12th grade. Segregate them for 4 hours a day. So what are the takeaways? It reiterated Rodriguez. It said it needed to go back to the state and that the state was already doing enough. So anything can almost pass muster. And that's the complicated thing. I did a piece in the Morrison Institute on the Flores case if you want to get more information. So some real quick final thoughts. We need more refined definitions and guidelines to help govern the concept of Title VI as it relates to English learners or multilingual learners. And is there a way to combine state constitutions and Title VI to make a more robust arguments? And then I'll vouch for him to say that we need more staffing at the Civil Rights Division. If 52% of the students aren't receiving services in Georgia, that means that we don't have enough people to actually bring forth the cases. Thank you so much.
Still morning, still morning. Good morning still. And thanks to Kimberly for having me and opportunity to see old friends and make new ones. And what a wonderful group of young scholars you brought in, Kimberly. So it's really been impressive to sort of see what they're doing. And also was occurring to me this morning because, Kimberly, I guess it's probably been here for a decade or so now. Even though some of the staff names here, and so I don't see Rebecca Claff, but every time we come, she does a good job to make sure everything runs perfectly. So thanks to her, although she's probably doing something else very important right now, I'm sure. So, but I'm going to try to talk about three things in 10 minutes. So discipline, school funding, and vouchers as a way to think about how Title VI has worked, how it might work in the future. So on the discipline front, discipline kind of got missed at the front end of school desegregation. We certainly were trying to move students into integrated schools, and Title VI and equal protection really driving that. But what we saw at that initial period was that when the spaces became integrated, discipline became a way to control Black students or pacify white parents, one or the other or both. And so you saw this sort of rapid increase at that period of time in the number of Black students being suspended, expelled. And we move on to sort of constitutional theories for dealing with school discipline over the years, Goss v. Lopez and other cases. But it really isn't until the Obama administration that we see OCR begin to dig back in on this. Not, Catherine's not here yet, but as I think I said a few years ago, I think she really is the most consequential assistant secretary at OCR of my professional life. And so really has been great that she's been there, notwithstanding dwindling staff. But if you sort of look at the sort of policy positions that they've taken or they took while she was heading that office, enormously consequential. So at that point, right, they issue their guidance around racial disparities in school discipline and also begin engaging in enforcement around those. And also to give credit to Erica, when we were getting prepared for this, Erica shared some data that she's looked at and put together around suspension, expulsion, and racial disparities. And instead of me just speaking in generalities or looking at the data she has that really confirms, right, you see this initial spike, right, during the early years of school desegregation. You see another spike, quite dramatic, during NCLB, and that affects students of all races and socioeconomic groups. But you see a really sort of high point right before Obama administration takes over. And then, you have a lag, before the guidance documents sort of begin to take effect, before the enforcement takes effect. But their work and of course, advocates across this country on the ground sort of pushing that, you see out-of-school suspensions really go down dramatically. So that's an enormous success. If you're trying to say, does policy matter? Does Title VI matter? Yes, it absolutely does. But then there's always the devil in the detail. And what you see are, I think, a couple of very troubling things is that although the overall number of suspensions went down for all students, the disparity went up. Now, I don't want to get too heavy in math. I think, Eric and I are probably going to talk over lunch a little bit more about this. But part of that is if you in raw numbers, you're basically reducing the raw numbers of everyone, that actually can accentuate some disparity. So I think it's good we have fewer suspensions and expulsions, but the disparity between black students' suspension and white students' suspension is way up. The other thing that's notable, right, that if you think about the social adjustment that America was dealing with in the 60s and 70s, and I said, oh, there's a spike in suspensions and expulsions, and you might have thought that spike led to like a really high number of suspensions and expulsions. It was really high compared to suspension and expulsion prior to that moment. But I think what you really see, clearly in the charts that Erica put together is that actually at, at now, right, black students are twice as likely to be suspended now than they were at the beginning of school desegregation. I don't know how we really wrap our minds around that in a way that we can say much of anything good. Okay, I'm stopping on this one. I'm moving to school funding. School funding, as Erica, again, we could have just let Erica have double time, but as Erica was talking about the history and purpose, right, we began to move money through Title I into elementary and secondary schools, primarily for the purpose of trying to create the carrot and the stick to desegregate them. So again, what we're trying to do is achieve a racial desegregation objective, but not necessarily worrying too much about the school funding implications, at least at that early period in time. And maybe we didn't need to worry about it. If you look back at the earliest expenditures of Title I, those were overwhelmingly going to poor and minority schools. So they were reducing the school funding gap. The problem, as I've said in some other work before, is that, the problem is everybody wants a piece of the pie. So all schools effectively get Title I funds now. I think it's like 70 or so percent. And so we took money that really should be targeted at a small subset of students in schools, and it's been spread to far too many and far too thin, in my opinion. So now we sort of think about school funding very late in the game, 1990s. A young lawyer comes to the Department of Education. She's sitting here to my right, and she works on a letter that talks about, well, how can Title VI begin to address this problem of racial disparities in school funding? Unfortunately, she and I may be the only ones that know that letter exists. I don't know. Maybe there's someone else in here. She sent me a copy of it, I think probably by fax a long time ago. But we're probably aging myself, not her. But in any event, so there was this letter that we really ought to think about this. Now, to Catherine's credit, again, the consequential nature of her being assistant secretary, OCR did issue a resource guidance document during the Obama administration that, again, says, right, here's some policies we ought to aspire to. But there's so many sort of practical tensions, I think, that's really impeded our ability to do that. And so when we think about school funding inequality and Title VI, we've got two pieces: funding inequality within the district and funding inequality between the districts. Within the districts, Title VI is actually in tension, if not at odds, with Title I itself. Title I merely requires substantially comparable resources. I won't go into a long lecture, but when we're talking about teachers, what that really, the only thing it means is that they all get paid by the same salary schedule, right? So no matter where you teach, as long as all the first-year teachers are getting paid the same, that meets Title I's standards. Well, guess what? As someone mentioned earlier, all the new teachers are teaching in the highly segregated schools. If there are more integrated or other higher income schools in that district, that's where the sort of elder and higher credentialed teachers are going to be. So you literally have a system on the Title I side of this that's allowing, I'm not going to say it's facilitating, but it's allowing the type of inequality that you would think that Title VI itself would prohibit. So we've got tension there. If we even look at Title I's own funding formulas, it just didn't occur to me until we were looking at states earlier. I think, again, some of the commentary that Erica was putting out. I mean, arguably, I haven't looked at this. I think there's a good chance that if you actually looked at federal funds and looked at where they're distributed across this country, there's actually a racially disparate impact to that as well. You say, well, how could that be? They do disproportionately affect students of color. I think when we look at regions, the answer is Title I, one of the primary multipliers in the formula is what is the existing state level of funding. And if we think about those lower funding schools and the lack of air conditioning in Erica's school, what we know is that our southeastern schools on average are spending less money per pupil than the rest of the country. And guess what? As a result of that, the federal government actually gives them less than it gives Massachusetts or New York. Another sort of big tension problem there. And then finally, if we think about the between districts inequality in school funding, the scope of the problem is so enormous, right? That we have state funding formulas in roughly half of the states in this country that spend less on the students who need the most than they do on the other students, right? And so I don't want to compare that to the political challenge of school desegregation, but it's a close cousin, right? If what you're talking about is using Title VI to tackle the entire structure of how schools are funded, at least in an administrative environment. Okay, let's move to vouchers, which is probably easier to tackle quickly. So on here, I'm really sort of pointing out the absence of federal intervention and application of Title VI. So there really hasn't been, as of yet, any significant federal regulation around vouchers, but we do see that vouchers are growing exponentially at this moment. The premise there is those are private schools. They don't receive federal funding. My premise is different than that. I think it's a premise, it's a factual point that some of these voucher programs actually are run through the State Department of Education. So the money flows through the State Department of Education. If what we're talking about are vouchers or ESAs in which the money doesn't flow through the State Department of Education, maybe it's a tax credit, maybe it's through the state treasury rather than through the State Department of Education, maybe there's no problem. But as to states like West Virginia, for instance, South Carolina, for instance, that money, before it goes out into the private schools or to the ESAs, comes through the State Department of Education. That State Department is a recipient of federal funds. That State Department is subject to Title VI. Now, that doesn't mean that we can regulate the private schools as a recipient of federal funds. I do believe we can regulate the State Department of Education and how it monitors discrimination in those schools. And as we see this expand, and I often think of them as being sort of state programs to facilitate private demographic silos, I think this is an incredibly important area for us to think about. Can Title VI, expand into this area? I think my time is about up, and we're getting close to lunch, so I'll sit down and hopefully we can get to some questions. Thank you.
All right, so I have a few questions for the panelists, but we also welcome questions from the audience. So if you just scan the QR code, you can send them. They're fed to me in a computer here. So we got to several of them on the last panel, and I hope to get to audience questions. Sure, but I'm going to start off with the few myself. So let's start with Dr. Frankenberg. Let's talk about, we've talked some about, or you shared in your presentation about some of the ways that Title VI has been helpful. But can you talk a little bit about some of the limitations that you've seen in its enforcement? And then the flip side of that is, Title VI, as you described it, was definitely used as more of a sword, right? And we think about some of these programs that are seeking to, for example, change the curriculum, remove certain books and topics from discussion. It makes me wonder if Title VI could also be kind of a shield in sort of addressing the disparate impact of some of the things that are happening. So that was kind of a two-part question, which lawyers often do. We'll say one, what are some of the limitations of Title VI as a tool? And then second, Title VI as a shield.
Let me actually talk about the second part first. I think there is a lot to think about in terms of what Title VI could use in this way, and thinking about the environment as being conducive to learning and welcoming for all students. I talk about this actually with my graduate students at Penn State. They can think too, are there decisions being made there that are how that relates in terms of curriculum, other things that go on. So I do think I didn't focus on that because I was trying to already do too much in terms of student assignment, but I think student assignment is, again, just foundational for the larger sort of climate issues around racial discrimination that Title VI talks about. And so I do think that is a really ripe area. And to the extent that I see a lot of things coming out of OCR right now around race, I see them more in that area than like student assignment per se. So maybe that transitions me then to the first question, the limitations. I think for some of the reasons that Jen He sort of alluded to already, there has been less use of it around student assignment right now. And perhaps that's in part because there are still, hundreds of cases that exist for racial desegregation that the Department of Justice has, and LDF has. And so maybe they feel like that at least is advancing that to some extent. I think there are a lot of things that could be done, though. I think thinking about how do you not just respond to compliance, but in a world of more plentiful resources, thinking about proactive efforts to say, okay, if you're opening a charter system, make sure you don't do these 5 things that we know could shape who enrolls. Like if you have a work requirement for parents, or you require transportation to be provided in ways that aren't similar to traditional public schools, that may shape who comes. Of course, the provision of language services, again, can shape who comes, things like that. So that could be one way that Title VI could help to address it. I think there are concerns, certainly, about the disparate impact. I think the Sandoval, also from the state of Alabama. Some of the best things come from Alabama. It makes a lot of law. We'll say that for Alabama. So I think there has been really a hesitance. I understand that. But I think also, too, the way in which we have a dwindling number of cases on the DSEG docket, and there's a lot of ways in which boundaries could be addressed. So we could say anytime you do a boundary change, you just need to have it reviewed by the U.S. Department of Education, which again, with staff they don't have now, right? To really think about it. Some of my other work with Genevieve Siegel-Hawley, who's over there, has looked at school district secession in the South, and overwhelmingly where we see these new districts being formed, they're in these white enclaves. And, so in addition to being able to prove that like financially you can afford to operate schools, can you also undergo a review saying this is not going to make segregation worse? And so I think that those are a number of ways. And then I guess just the last thing to think about, virtually every state, again, has an open enrollment program. Charter schools are even kind of open enrollment. So if you take Derek's model of state departments of education receive Title VI funds, well, maybe those state policies should be reviewed. I even think more dramatically, and this is not politically feasible right now, but school districts are created as agents of the state. And so this is what Milliken was in part looking at, and the Chef case, how school district boundaries, the New Jersey case going on right now. Can we look at the way the state has created school district boundaries and think about whether that is something that goes against Title VI?
Thank you. Yeah.
I was just going to kind of say about the question you raised with the curriculum that I don't know if people saw it, but OCR did have an enforcement letter in Clayton County, and it was we'll just say very complicated because they had to make sure they were within their boundaries. But at least looking at the motivational aspect of why they made the decision to change the curriculum and how that affected the environment for the students. So that's important. I don't know if they've had any more enforcements around that, but that letter I do recall coming out.
I mean, I can
Yeah. Jump in.
Yeah, I can talk to that because when we saw this kind of spate of state level legislation, but also actions at the school district level, kind of lumping everything into critical race theory. I mean, everything. And some of it was, banning censoring curriculum or books, about Ruby Bridges, or banning, celebrating, African American History Month, things like that. There was a lot of effort, on the behalf of civil rights organizations anyway, to ask to OCR to kind of speak up, using their position. And I think the complication, as was kind of, I think, communicated to us, was this distinction between curriculum and, as not being within the purview of the federal government. That's usually reserved for the state and local governments, or state governments. And I think the hostile environment, though, is obviously how that comes into play, and that's had a tremendous impact on that, in addition to this push to ban diversity, equity, inclusion, and access, where, those words are now, kind of coterminous to discrimination in some places, which has only exacerbated the hostile environment. But OCR did issue a really great guidance, kind of indicating that, the SFFA decision did not have an impact on DEI and education. So, but I think that it's just been a very precarious time right now, because the state governments have been just so aggressive and so at odds with what the federal government has doing, that everything, anything that we would think is kind of sensible is just fraught in terms of this current political climate.
Yeah, so let's actually build off that answer and talk a little bit about SFFA and what that means for K-12 schools. So what are the implications of the decision? And can you talk about attendance, but also other areas for what SFFA means?
Legally, it really should have no impact, because it is just very narrow. I mean, we're talking about just considering race and admissions to higher education, and it's, very different from K through 12. That's never been, there was a decision, a decade ago about not being able to do that in a K through 12 context when it comes to student assignment. I mean, the explicit consideration of race, but you can look at other kinds of factors like zip codes and socioeconomic status. I think what the biggest consequence of this is that, kind of, to be honest, I think some people do not think that segregation is necessarily a bad thing, because that's essentially what they're kind of arguing, is that racial segregation in education is, not due to discrimination, but for other, kind of consequences. So think about that in the higher education context. I mean, there's a real concern about the segregation of our, kind of most selective higher education universities. That was one of the reasons why we had affirmative action in the first place. There's just this ongoing falsehood that, that given natural events, students would actually just kind of go to the schools that they're most qualified to go to, which is completely contrary, obviously, to evidence and facts. But that is kind of underlying the sense of, again, not, this attack on just looking at numbers alone, and that racial disparities are indicative of some sort of, kind of invidious discrimination that's going on, as opposed to this is just the natural course of events, and that if you kind of address the disparities, you are in fact discriminating against students who are in the majority. And I would include, I think what's complicating that is that it's not only white students, but often Asian American students who have been joining in this kind of challenge to these kinds of race equity efforts. I'm not saying all Asian American families, but there's been some prominent ones. So even before the SFFA decision, there's just been some legal challenges saying, for example, making kind of gifted and talented middle schools more equitable, because there was a huge racial disparity. That was discrimination, because school board members were very, very forthcoming about the fact that they wanted to address this severe racial disparity, even referring to the George Floyd protests, and this is a case that we're involved in. And the fact that even a reference to George Floyd, they kind of pointed to as evidence of racial discrimination because it was clear that the intent was to benefit Black students. And so these are the kind of arguments that are happening right now. And I think that's also true in terms of, kind of admissions to various, high schools and so forth. But I think the danger, and there's, right now it's been limited to these very scarce educational resources or competitive resources, but the trickle down effect can be very enormous because essentially what they're trying, what is the effort, the larger effort is to kind of make very clear that any intentional effort to address racial discrimination without some sort of underlying proof of intent that's a very high standard, like that in itself will be a form of discrimination because, the percentages are going to change, obviously, because that's exactly what you're trying to do. And so that, I think, is what is going on right now. We're seeing that in employment context. We're seeing that in contracts, there's a lot of press about, programs for scholarships for specific racial demographics. And so this is just, going to continue. And I think because there's been just a lot of people who've been emboldened by the SFFA decision because it was such a sea change in the current existing law.
Yeah, sure.
One of the other things that I've been looking at over about a decade is the extent to which K-12 districts are engaging in voluntary integration. And this is a closer analog to like higher ed than maybe the other things we've been talking about for K-12. And what is very apparent to me in the last 5 years or so, even as these cases were winding their way up through the courts, is one, almost the absence of anything that uses even a generalized version of race, or again, which was within the guidelines of what the Parents Involved decision said in 2007. But second, and completely understandable, the real lack of transparency about what school districts are doing, because they're worried that anything they're doing, even if it doesn't even explicitly invoke race, will be subject to challenge. And when these are being done voluntarily by school boards that are subjected to regular elections, they, understandably maybe don't want to incur political or legal risk. Legal risk can obviously be very costly. And so I just want to, when you talk about the trickle-down effect, there are over 100 districts, right, that have some form of voluntary integration to the extent that we even know. And it is just really unclear what is being done now. And I think that's a real disservice to being able to help other districts know, like, is this effective? To the end of the last panel, is this an effective thing? How can we measure it when we don't know? And so that's a challenge right now in this space.
And just to add, I think it's beyond just voluntary integration. It's, some school districts have these race equity efforts where they're looking at school discipline, where they're looking at a host of areas where there may be some racial inequity that's, been long established and so forth. But just even to say that you're kind of embarking on an effort to deal with a racial inequity, like using that term, and sometimes it's not even, you don't even have to say that. But if the impact, the effect of it is to benefit Black students or Latino students or whoever, like there's going to be an attack. I mean, even removing a test, for example, and race neutral efforts have been challenged because the number of students who've been able to benefit from a program have decreased for white and Asian American students.
Thank you. All right, so Dr. Jiménez-Castellanos, you talked about just the very minimal and limited standard for making sure that students who are multilingual learners are that their rights are protected under Title VI. Can you talk about what you think that those protections should be? What direction should we go in?
Right. I mean, that's a little bit of a complex thing, especially given in the times in terms of the courts. How much can you actually push right now and get implemented? I did want to make a reference. I in my talk I overlooked Castañeda v. Picard 1981 as well, and that provides the three-pronged sort of test, which is a sound educational theory, implemented effectively, and evaluated as effective. I mean, all of that sounds great. But then who has the power to decide what is sound educational theory? who has the power to decide what's implemented effectively? So it's one of those things where on the surface it seems like it could be operationalized. So how could it be operationalized? In the previous panel, the concept of dual language came up as sort of a potential solution, especially for multilingual learners. Yes and no. Those of you who are familiar with dual language, it's a program that sort of incorporates both non-native English speaking and native English speaking students together, learning together, and so forth. Um, Originally bilingual programs were focused on really trying to advocate for students that were poor and students that really did not speak English as a primary language. The dual language programs have really, to some degree, been gentrified, right? In terms of where you actually see dual language programs is where all of us may live, right? Middle class, upper middle class communities. And at best, there's an entrance convergence that I don't think was mentioned earlier, meaning they're implemented and they import the non-native English speakers to fill in some of the gaps to help native English speakers learn that second language. So I would say that, dual language programs offer some potentiality, but again, in practice, they're actually being gentrified. So you're actually seeing more native English speakers enrolled in dual language than non-native English speakers. So I would just put that as a caveat, as a caution to all of us that would run to that as a silver bullet. But I think, what we discuss in this edited issue, Kimberly, it really is thinking about sort of moving towards multilingualism, right? So not necessarily only dual language, but really there's a variety of bilingual, multilingual programs that are good for all students, as was mentioned earlier, meaning, those English learners that get reclassified to non or fluent English speakers, what's really interesting is they outperform everyone else. That's what people don't understand. And so, in Arizona, for example, we have the same superintendent Horn, remember the Horn v. Flores, back in office in Arizona. And he actually sued school districts that were implementing dual language programs for language minority students, right? So, so we got this sort of really aggressive sort of counterattack, if you will. It's sort of it reminds me of the CRT, the banned book argument. It's like going after what, culture and language really is the solution and how we operationalize that in benefit of language minority students. And I think, one example would be, the Bilingual Education Act, which is really part of the original Elementary and Secondary Education Act, right? Title VII. Those of you who know, it was moved to Title III and was renamed as Office of English Language Acquisition. So I think, what we need to do is now push back and really think about, like, how can we bring multilingualism back into the conversation in terms of the vocabulary? And then how do we embrace a variety of bilingual programs to serve all of these different communities?
Thank you. Professor Black, let's talk about some of the greatest obstacles to Title VI remedying racial and national origin disparities in topics like school funding and discipline. What are some of the obstacles that we're seeing?
Yeah, I think the largest obstacle there is probably the size of the lever itself. I mean, as I alluded to in the earlier conversation, if you think about the size of the school funding gap, that gap is larger than the federal funds that those schools are already receiving. And so, how do you get a state who's got a a 10% funding gap to close that gap based upon 7 or 8% funding they're getting from the federal government, the answer is they may very well not do it. I mean, we certainly have seen Utah at the beginning of No Child Left Behind say, we're not even sure this testing gig makes sense for us on a dollar-to-dollar basis. And then my place of origin, Tennessee, for whatever reason, said, maybe we're going to give all the Title money, Title I dollars back. I mean, that would have been ridiculous. But in any event, so you do see this sort of conversation. They don't even think that the Title I dollars are worth the testing to some extent. So, I don't see how, I mean, even if Title VI required it, I don't see how that would be an easy lift. But I think there's an easy solution to that. During the prior presidential election, not the current one, there was tremendous amount of conversation around increasing Title I funding, quadrupling it. I sort of pegged it at being quadrupling as being the right number, and we had some COVID money that got us there. But the short story is, I think that if what we did was exponentially increase that, right? Let's say we quadruple it, then you could set a 10-year time frame for saying reduce X amount of your funding gap per year. And I sort of point out that if you think about how, and I know you've written about Title IX as well, that Title IX has this sort of three-pronged standard, which is, well, if you've eliminated, your disparities, you're good. But if you're making progress, that's sufficient. Now, I'm not saying we've eliminated all of our gender disparities, but man, we've made a lot of progress by saying on an annual basis, you need to be making progress. I do think bigger federal investment and then a timeline for closing those gaps, that would be possible. On the discipline side, I would just say, relating back to some comment or some research I did previously, I think we so often disaggregate school discipline from school funding and school quality. And ultimately, what happens in terms of discipline is a function of the quality of education, which is a function of money as well. And so I think to really have Title VI work well on the discipline front, we got to have well-resourced schools that can implement the programs and have the resources that we need to have effective discipline resources that produce good education outcomes.
Thank you. All right, we've got some questions coming in from the audience, so I'm just going to do a couple of those, and then we are going to break for lunch. I know it's lunchtime. So, Dr. Frankenberg, could you discuss the impact of the recent Pennsylvania decision regarding school funding inequity and the organizing efforts to sort of recalibrate for other states given Title VI? Can you talk about that for the audience? Maybe explain what happened first and then Title VI implications.
Sorry to talk over you.
No, fine.
In Pennsylvania, there had been a many years long effort to build a state funding challenge to the way that Pennsylvania funded schools. Ultimately, a successful decision, I think, in February of last year, finding that that the schools were both not funded enough and not funded equitably. The challenge is always, of course, you have a violation and then you need a remedy. And that, I think, is always a challenge in education. So what I really appreciate that has been going on in Pennsylvania is this effort to also build public support for a remedy. And so, I know I live in the central of the state. It's not a big urban center, and we still had some fair funding rallies. So really trying to say this isn't just an urban problem. This is a rural problem as well. Some of the rural districts were some of the lead plaintiffs, and that has traditionally been one legal strategy that's been successful. I do think actually when we think broadly across what we're doing, I've always wished that in school desegregation context, we did more organizing around remedies as well, both to put political pressure on those who are going to be implementing the remedies, but also to make sure they're responsive to what the community wants. And so, we're not all the way there in Pennsylvania by any means, although we do have a dramatic influx of new dollars and they're being allocated in more equitable ways. There still are dollars that are not being allocated in equitable ways. But it's taken over a decade to get that to work. And I've also seen other states, again, not to harp on my poor home state of Alabama. That's like, why did you ever live here? But we had a violation for school funding. Again, I went to an air-conditioned school, and the legislature said, we don't have to do anything. And the court said, okay. And so I think that just underscores the essential nature that though we need lawyers in here, and I don't want to dissuade law students, we really need others also working to try to bring the political pressure, because we could consistently see we need multiple branches of government.
Can I
Yeah,
add really quickly? I was a consulting expert on the Pennsylvania case as well, and I think one of the things that I just sort of I'm rethinking school finance, and really post Serrano, 1971. I argue that we're sort of in a remedial, compensatory funding frame of mind. So even when we adjust our funding levels slightly, what the trickle down effect many times for the school districts and the schools is that those funds are used to remediate education. So my research has shown that what does that mean in practice? Test prep, um, paying for someone that will do compliance work because they need to fulfill certain requirements. And so to me, it's sort of like the question becomes, in terms of the remedy, is how do we go beyond sort of like this deficit mindset of how we use those funds? And many times the remedy is focused too too distinctly on federal funds. Federal funds are important, but again, 10% of the of funding comes from federal funds. So what's really missing is how do we actually increase the base funding for students, and especially those under-resourced schools, because that's 90% of the funding at the state and local levels. And what we see in places like Arizona as well, maybe Alabama, is that the more the federal increases, the less the state actually generates, when there's a population that's becoming much more diversified. So it's really sort of this really interesting space, as money is necessary, but it's not enough.
Thank you. All right, I want to make sure we wrap up. So I usually like to give panelists a chance, just like a 30-second closeout statement. What would you like us to? We'll start on this end and we'll go down to Derek.
I'd like to close out with just something that I forgot to mention earlier, which is so important with everything that people have been saying, and that is also just the challenge of a potential challenge of collecting racial demographic data. And that is already happening, because there's a case in the Fifth Circuit challenging racial demographics of broadcasters, in compliance with with federal communications commission's requirements. And we also saw that with colleges and universities, even though it was not required by the SFFA decision. Many universities just declined to collect racial demographic data at the time of the admissions process. And so, and obviously, data is so important for us to really analyze these problems and to find solutions. And so, so that is something too that I think, just something to be very careful about, especially for researchers, in terms of trying to kind of have any kind of influence of the important need of collecting this kind of data. It has tremendous ramifications in all areas, certainly education, but that is something that we are anticipating coming soon.
Just again, want to thank you, Kimberly, for the invitation, and congratulations on the 1-year anniversary of your institutes. I guess my plug would be here is and I appreciate sort of the interdisciplinary nature of this symposium and this conference, because educators aren't going to solve the problem on their own. Politicians, definitely not. Lawyers are definitely not. So it really sort of creates sort of this need and opportunity for us to collectively think about these big problems in more interdisciplinary ways that involve sort of how do we go into advocacy and legislation, as sort of Ari and the first panel really talked about.
I appreciate, Jinhee, you bringing up the data because right now we're in a space in which the way discrimination is operating, as I mentioned earlier, is it requires more complex cases to be able to build the case for why this is a violation of Title VI. And we are lacking the data systematically already at the K-12 level. And we have really important national data sets, but there are also huge limitations that exist in terms of showing privatization choice boundaries. So I think the data is really critical. We need to build it up so it can be assets both in Title VI, but also just in helping communities engage in thinking about what would be more equitable. I think we really need to look carefully at the way choice is being designed and implemented, particularly how state agencies could do something differently. I think the boundaries issue is really important. Boundary structure, over 70% of where kids go to school, and of course also affect resources. And we need to think about that in really important ways that we haven't historically. Or we actually did, but then we stopped doing it. And then I think the last thing is just to think about cross-sector, and we haven't really touched on that yet. Schools and residents are inherently linked, and we need to really think about how we look at interventions that look at both residential and schools and transportation all collectively, so we're not putting all the weight on schools to do this work on their own.
Well, there's been one institute that we haven't said. It's probably been mentioned less here than any other conference we go to, and that's Congress. I can understand why we're not talking about Congress, but I think if yeah, they do a good job. But if levers matter, and I think they do, I think we actually really need Congress again. And since Catherine's with us, I'll say again, I think she's the most consequential assistant secretary of OCR we've had in my professional lifetime. But I do feel that we are reaching the limits of what that office can do without Congress, particularly given what the Supreme Court's been saying about agency deference and disparate impact. And so, if we rewound, and it seems like it was a different world 12 years ago, there was enormous push in the Leadership Conference for Civil Rights to get a fix for Sandoval, right, to have Congress pass legislation to respond to that. And I don't know if I've heard anyone in the last 10 years mention that. And I do think as we reach rightly or wrongly, the edges of administrative power, I think we really do have to re-engage and find the politics to have Congress engage on that. And since we're all educated, I hate to say but just for us, you don't want to box it up, but I do think given the affirmative obligations that states have in public education, a fix for some aspect of public education makes sense, because that sort of guarantee of meaningful access and making sure that students are getting that meaningful access does interact with disparate impact in a different way than it does in healthcare or transportation and other ways. So in any event, that's my plug for, my goodness, we need to talk to Congress about a potential fix around Title VI in education.